All right. Hello, everyone. Salam, namaste, adab, and welcome to today's session. We are going to hear Dr. Sona Khan, an eminent attorney at the Supreme Court of India, who is a constitutional and development law and Islamic jurisprudence expert. And the topic is controversy over Indian Citizenship Amendment Act, popularly known as CAA. And she will be formally introduced by Dr. Bhanumati Sharma, who is an associate professor at the Department of Human Development and Childhood Studies at Lady Irwin College of University of Delhi. And the concluding remarks will be given by Honorable Ambassador K.P. Fabian, the former ambassador to Italy and to United Nations Food and Development Organization, Agriculture Organization, who is also currently a distinguished fellow at Symbiosis University in Pune. So welcome you all. And now I welcome Dr. Bhanumati Sharma for the formal introductory remarks.
Greetings to all in the session. Thank you to the organizers for inviting me to this session on a topic that has engaged the attention of all. In a world as it is now, plagued by great uncertainties and turbulence, the place of individuals in groups and of communities in nations has become a critical concern, rightly so. The construal of citizenship has engendered disparities and disputes that demand our concerted action. Quite clearly, the topic for today's session is timely and extremely relevant and demanding deep and serious deliberation. This session promises to engage us as we listen to the observations and insights of our speaker, Dr. Sona Khan. It's an extremely pleasant duty and privilege to say a few words about Dr. Sona Khan before she's invited to give her talk. An eminent attorney before the Supreme Court of India, Dr. Sona Khan is a barrister, a constitutional and development law expert, and an Islamic scholar. She's also a columnist for a number of leading national dailies. As an advocate, she has dealt extensively with cases related to Islamic jurisprudence. She's renowned in India and beyond for her work on women's rights. In 2003, she was made the Hall Distinguished Fellow at the Klaus M. Hall Institute for Global Learning, Emory University. Dr. Khan, in 1985, successfully argued Shah Bano Begum's case before the Supreme Court of India, which, in a landmark decision, overruled the prevailing customary Muslim law. Later, the Indian Parliament effectively tried to negate the Supreme Court's decision by exempting Muslim women from the secular code used to decide the case. Dr. Khan challenged the legislation in the Supreme Court and again received the order from the Supreme Court of India that it is obligatory for the husband to maintain his wife even after divorce till she's alive or is remarried, and that law prevails today. Dr. Khan has also battled to end child trafficking in South Asia, where over 100,000 children a year are sold as sex slaves. She has helped in drafting the constitutions of Eritrea, Afghanistan, Somalia, and is now evaluating some of the amendments of the Indonesian constitution. Dr. Khan's successful defense to save the Nigerian woman Amina Lawal, ordered to be stoned to death for adultery and fornication, saved her life and other women placed in similar circumstances. On a more personal note, may I add that having retired after 4 decades from the Lady Irwin College, University of Delhi, I cherish my time as a member of the Institutional Ethics Committee for Research at the college. It was in this committee that I had the opportunity to work closely with Dr. Khan. Her deeply sensitive approach to the ethics of research endeavors enabled and strengthened our research with human participants. Thank you very much, Dr. Khan, for speaking to us. Do I also introduce?
Gigi, if you wish, yeah, sure.
No, I introduce Dr. Ambassador Fabian now, later.
Yeah, you can introduce now because once we start, yeah, sure.
Okay. It's my pleasant duty again to present Ambassador K.P. Fabian, whose concluding remarks we will look forward to. Ambassador Fabian has served in the Indian Foreign Service from 1964 to 2000. He was first secretary in Iran from 76 to 1979 when the Shah fell. Ambassador Fabian's last posting was as ambassador to Italy and the permanent representative to the FAO. Post-retirement, Ambassador Fabian taught at Jawaharlal Nehru University, New Delhi, and the Mahatma Gandhi University, Kottayam. Currently, he is a distinguished fellow at the Symbiosis University, Pune, and professor at Indian Society of International Law, New Delhi. As a writer, Mr. Fabian has authored Common Sense on War on Iraq, Diplomacy Indian Style, The Arab Spring That Was and Wasn't, and he's currently working on Israel-Gaza. Thank you, Mr. Fabian, for presenting the concluding remarks after Dr. Khan's talk today. Thank you.
Thank you, Dr. Sharma, for your kind words. Good morning, good evening, adab, sat sri akal, namaskar. I am very grateful to this forum for inviting me to share my ideas on a very controversial topic, which is presently being very discussed in a very critical way in back home in India. But it concerns all of us because it deals with the basic principles of human rights, equality, and also recognition of our neighbors' problems and their difficulties, which as a neighbor in India, as a neighbor cannot ignore. The CA, which is being called, is in fact an amendment to the 1955 Citizenship Act. This is not the first time that this act has been amended. This is the 6th or 7th amendment since its inception. Now, in this amendment, what is more particular and curious to everyone is the use of the faith. Never before in the history of Indian jurisprudence, and ever since the Constitution has been proclaimed and adopted, no one has ever used religion as an instrument of discrimination of any kind. So this is precisely the problem. And how is that? Because according to this legislation, which was passed in 2019, the 3 countries have been identified: Pakistan, Afghanistan, and Bangladesh. And the people flowing from that country into India, entering legally or illegally, whatever, and later on became illegal immigrants after the lapse of time because their visa had expired or their passports had expired, will be able to expeditiously get Indian citizenship through this legislation without having to wait for, like others who have to wait for 11 years. In this case, it will be only 5 years. And this expediency, in fact, is justified on account of the fact that these people coming from those countries and only of Hindu, Sikh, Jain, Bauddha, Christians, and Parsis have faced persecution in their countries. Now, but there are many other communities who also face persecution in those countries. They have not been included. And this is discrimination, which is being very heavily discussed back home. Now, by virtue of this legislation, few things have happened. First of all, these communities will be able to pursue their applications online. They don't have to go anywhere. Online, they apply for being included in the list of citizens of India, and they will be considered favorably. Now, what is the criteria? Criteria is that they should be should have been prosecuted back home or have the fear of being prosecuted. Earlier, it was said that persecution will have to be established. But now, with the pronouncement of the rules relating to this legislation announced last month, there is no need for a person to prove that he or she has been persecuted, but only have to say so. And if they fall within the domain of these 6 religions, as I mentioned, then in that case, they will not have to even give any evidence of kind. This is something very strange, and it is considered to be something very, very arbitrary. However, the timings of declaration, the rules of this legislation, which was passed in 2019, somehow is a matter of concern, because India is going to have general elections for its Lok Sabha, which is the lower house of the parliament, in few weeks' time. And in order to generate certain controversies, certain amount of discussion, which is bound to take its own toll on the result of the elections. This is what is being perceived. However, be as it may, the matter is of great concern to everyone, those who are not even based in Delhi, based in India, elsewhere also. Why? Because many other communities from within Islamic and non-Islamic communities have also been left out. For example, we have from the report from the 2011 census that in India there are about 100,000 Ahmadiyyas living as refugees. They came from Pakistan. They have not been included. What will happen to them? Then we have large number of Tamil stuck up in Tamil Nadu. Some of them are in the detention camps. What will happen to them? Then we have Chakmas, who are both, and they came from Bangladesh. What will happen to them? They have not been included. The people who don't believe in God, atheist, they have not been included, and these people are very heavily persecuted in all these 3 countries, which happen to be following a very strong and strict code of Sharia law. Now, Sharia law prevailing in these countries has a written and unwritten constitutional value. But in India, we have a written constitution. We follow a parliamentary democracy. And in that democracy, all actions of the government are accountable. And as a result of that, there are 237 petitions pending before the Supreme Court for the consideration whether this act, this law, qualifies to be valid and will be applied accordingly. However, no stay has been granted. There are 237 petitions from various parts of political activists, political parties, non-political activists, and NGOs are pending before the Supreme Court. The Supreme Court is seized, and they are at the moment, as we speak, are considering the arguments presented by various parties, various petitioners. And in this context, I would like to present that how will the Supreme Court look at this legislation. The first point for consideration is the discrimination. The Article 14 of the Indian Constitution guarantees equality and equality to all, and equal protection of law to all. Now, when I say all, that means all those people who are present on the territory of India, just not a citizen. This right is available even to non-citizens. So if you feel that you have been discriminated, you could go to the court and you could ask for a redress. In this context, Samaiullah's case from Jammu and Kashmir, who is a Rohingya refugee in India, filed a petition when he and two of his old family members were picked up. The Supreme Court came handy and they granted him stay, but at the same time advised the administration to take a course according to law. The other aspect of equality law in India is that nobody can be discriminated without due process of law. Now, what is the due process of law? Due process of law is that you cannot go and pick up anybody from house or from anywhere on the street. You have to establish an a fair investigation in order to deprive that person of the liberty or freedom that he or she enjoys as a citizen, or even as a visitor, or as a refugee, or even as an illegal immigrant. So India's constitution gives very wide powers to all people and is very concerned about human rights of all. So therefore, this legislation on the grounds of equality will not pass the test. However, there is an argument being given that there is a provision of reasonable classification as when equality is applied. This has been borrowed from the American Constitution. Indian Constitution did not have it to begin with. The Supreme Court of India looked into some of the cases where it was applied. And they found there are two conditions necessary for a reasonable classification. And what are they? That the object of discrimination must be laudable, must be honest, must be sincere. And the second is that the process should link and lead to the main objective. In this case, the faith has been considered to be the criteria for grant of citizenship. Now, faith only of 6 religions and rest have been left out does not really justify the linkage with the objective. Because Ahmadiyas, the Rohingyas, the Tamils, the Chakmas, the Hazaras in Afghanistan, they are also persecuted in these countries. So if we are talking of persecution, then in that case, they should have also been included. And since they have not been included, therefore, the linkage of reasonable classification does not really pass the test as far as this law is concerned. So I very strongly feel that the Supreme Court will apply, even if they apply the reasonable qualification. Then in that case, this legislation is not going to pass a test. The other objection, and the critics are very severe about it, is that it violates the basic structure of the Constitution. And what is that? The element of basic structure of the Constitution, the secularism. The whole ethos, the philosophy, the ideology of the Indian Constitution is based upon secularism. It even is included in the preamble of the Constitution. Now, if you look at the right to religion, Article 25 to Article 30, how minorities are going to be treated in this country are very elaborately discussed, and it is designed in such a way that they don't feel insecure. Whereas this legislation gives a feeling of insecurity to people who have been left out, and the Muslims are the one blatantly who have been left out. At the same time, people are also saying that secularism has been used in order to invite these people, or in order to give citizenship to these people who seem to be persecuted in their own countries. How is that secular? You are inviting them to become citizens of India and leaving the others. How is that secular? That's kind of a secularism, in fact, is very, very selective and biased. And that is not acceptable to the Indian Constitution and will not be acceptable to the court. This Article 14 to Article 18, talking of equality, does not mention anywhere that people of certain faith only would receive the equality. Equality will be meant for everyone. So therefore, faith for the first time has appeared as a reason for grant of a privilege or immunity to those people who have violated the law in some way or the other. Now, it is not just now that BJP, the Bharatiya Janata Party, which is the lead party in the coalition of parties heading the Indian government, it first came into power in 1998. From 1998 to 2004, under the leadership of the Prime Minister Atal Bihari Vajpayee, they governed for 6 years. During the 6 years, they changed the laws relating to immigrants in a massive way. How? They changed the Passport Act of 1946, in which the punishment for violation of the rules of the passport were only punishment was only of 3 months and fine, whereas it was increased from 2 years to 8 years. Now the law is it is 2 years to 8 years. The illegal entry into India was punishable by 3 months. It was changed from 3 months to 5 years. Now, having done that, they realized later on that this is not going to curb the influx of immigrants, especially from a neighboring country like Bangladesh, which had a lot of problem when East Pakistan, the government of East Pakistan established its domain as a Muslim country. The Hindus felt very insecure. They were persecuted. And more than that, more than the religion, the main thing was language, because Urdu was imposed on them, and they were Bengali speaking. They could not adjust with that language, the official language, and they found left out. They could not read and write. It was too late for them, most of them, to learn the new language. And Bengali language was not taught in the schools as used to be earlier. The people who really felt uncomfortable living in Bangladesh at that time started thinking of moving around. And the borders of India at that time were very porous. They are not anymore, but at that time were very porous, and it was very easy for people to come and go, because after all, it was a part of India at one time. Most of them entered Assam and West Bengal. In Assam, they were concentrated in the Brahmaputra Valley and beyond. Now, this legislation does not apply to the tribal areas of Northeast. So people question, if it is not good for the Northeast areas, how it is good for the rest of Assam and Bengal. Now, the real problem for this to facilitate undoing of the problems of immigrants in Assam and West Bengal is the fact that during period of 1998 to 2004, very strict laws were made, thinking that the strictness of the laws probably would hamper, would prevent, would discourage people flowing from Bangladesh to India. But that did not happen. Somehow did not happen. It is still happening. Though Bangladesh at the moment is in a very economically in a very good position, the people don't have to move out from there because of because of economic reasons, which was earlier the case. They found India to be more beneficial, more suitable, more friendly, and therefore and also in West Bengal and Assam, the language problem was not there because they also speak Bengali, though Assamese have their own distinct language, but which is very close to the Bengali language. So therefore, it was very comfortable for them to be able to re-establish themselves. As we have a few cases, like Taslima Nasreen, who is settled in Kolkata, and she is very happy being here, though she has not taken the nationality and she has not asked for the nationality. She enjoys a long-term visa on very special basis. However, the people in Assam are uncomfortable. Why? Because they think with the influx of people from Bangladesh, their culture, their language, their literature, their ethos are being overtaken by them, because the number of immigrants, the illegal immigrants or immigrants otherwise from Bangladesh is rather very, very large. And they feel suppressed. They think that the domination of the culture of Bangladesh will destroy the inherent qualities of the culture of Assam. The political organizations, the student unions, they are up in arms. And this has been going on for a long time. The first time when central government intervened there was 1973. And illegal immigrants tribunal was set up in order to find out who is illegal or not. And the cutoff date at that time was 25th of March 1971, when Bangladesh came into being after getting away from Pakistan. And at that time, there was a tremendous violence, a lot of massacre, and India really helped the refugees coming from Bangladesh, the people migrating from there. Later on, this migration was considered to be very conducive for the economic interest of some of the people. People in Assam and West Bengal found the availability of cheap labor, which was very conducive for promotion of trade and manufacture of goods and agriculture also in these two states. Now, as far as Assam is concerned, they were not very happy with availability of cheap labor. They found that the limited resources available for like the educational institutions, the hospitals, the healthcare, the land for agriculture is being taken away by these immigrants and leaving very little left for the original inhabitants and citizens of Assam. So as a result, an exercise was conducted, but later on, the act under which this tribunal for determination of illegal immigrants were set up, those were that legislation was abrogated by the Supreme Court in 2005, because they said this is not helping the situation at all. Why? because the burden of proving that so and so is illegal immigrant was on the authorities of on the state and not on the person. Earlier, the situation was that you have to prove you are a citizen of India, or you are not, you are immigrant, illegal, or you are have a valid document to enter into India. And if you did not have it, well, too bad. But in the case of this, for the termination of illegal immigrants, the tribunals, the burden was on the state. And therefore, the state was not able to go ahead and make a kind of a determined survey, as a result of which there was a large number of people who were able to get documentation made, acquire even voter cards, Aadhaar cards. Some of them even had nationality certificates by naturalization. Getting documents is not a very difficult thing in India. It can be done. Though at a certain price, but it can be done. And therefore the government and the Supreme Court realized that this is not working out, and this is not solving the problem of Assam, which was constantly burning, and there was a tremendous amount of resentment and violence, and providing political instability in that state. So what did the Supreme Court do? It set up its own committee under the convenership of a very well qualified IS officer who did a very scientific job in order to determine. Incidentally, the outcome of that exercise, which was called National Registration of Citizenship, which has become a matter of great concern now. Why? Because if this exercise takes place again, the apprehension is that many people who are really citizens of India will be left out because they may not have the documents to show. This whole exercise is based upon the documents that your connection with India, or of your parents, or of your grandparents. And if you are unable to show, and how are to show, you should have a property document, you should have birth certificate, you should have education qualification certificate, you should have an insurance policy, you should have a bank account, you should have admission in any of the educational institutions, and any document to show your connection with India, legitimate connection with India, and also the possibility of explaining that you have been here for a long time. Now, what is that period? For any person to apply for the citizenship of India by naturalization is 11 years. But as far as this legislation is concerned, and to these people of six religious denominations, the period has been reduced from 11 to 5 years. This is also discriminatory. It's arbitrary. How can people belonging to only a certain section of society based upon religion, faith, can have immunity from the prosecution of being an illegal immigrant and not others? This exercise of registration, maintaining a national registration of citizenship was done, in Assam, in which it was found that more than 9,600,000 people were found to be illegal immigrants. Out of that, mostly more than half of it are found to be Hindus and not Muslims. This exercise was done, in fact, to find out who came when and what is the religion of this person. Now, these people who have been left out of that, left out and found to be illegal immigrants, what is going to happen to them? So, as a result, the government, the present government in that power, also has the same kind of a political party in power in Assam. Try to undo by virtue of this this legislation, giving a special treatment to people of these 6 religions, and increase their own vote bank. When I am talking of a vote bank, unfortunately, in Indian politics, vote bank has played a very big role since the decline of the power of Congress party into the political arena. In 70s, the fatwa system started. Political leadership approached the mullahs and Muslim organizations to get fatwa that you vote for this particular party. And that was invariably Congress. Even the person like Mr. V.P. Singh, who claimed to be different, though was from the Congress, but claimed to be different, he also, I remember, invited Mr. Bukhari, the then Imam of Jama Masjid of Delhi, to issue a fatwa that people should vote for his party. And it was done. Fatwa was issued. He went to Deoband. He went to Imam of Allahabad, which is now Prayagraj. The name has been changed. And it was done. Whether it had an effect or not, I'm not so sure. Only the sense, the political parties would know, or the election results can tell us. However, this was sad because this vote bank politics has really played havoc with the lives and the perception of Muslims in India. When this legislation was introduced in 2019 in the parliament and passed, there was a huge protest in Delhi and all over. At that time, motivated by this vote bank politics, one of the ministers of the government, which was BJP, he continues to be a minister even now, he used very derogatory terms, considering all Muslims to be traitors in this country, which was very, very upsetting and annoying, even to the people who were not concerned with politics at all. How can you do that? Simply because they happen to be Muslims. This vote bank politics is the one motivated in West Bengal and Assam now to bring this legislation in order to woo the Bangladeshi Hindus who are in large numbers. People who came from Bangladesh as Hindus, most of them were underprivileged from the lower caste. Caste system is very heavily embedded in Indian politics. They were scheduled castes. What would probably you are familiar with the term called Shudras. Most of them were from the they are now known as Matuas, and the BJP thinks that they would probably be able to woo them with this legislation and have a vote bank, a solid vote bank for them. And same goes for the Rajbanshi community, which is a scheduled caste, recognized as a scheduled caste. And if they applied for this and they made application under this legislation for being granted citizenship, well, they are bound to thank the party in power, which facilitates this kind of a easy way to get the Indian citizenship. However, the present Chief Minister of West Bengal, Miss Mamata Banerjee, she has said that this is a trap. This legislation, if you apply, would be a trap because then you admit that you are a foreigner. You are not a legitimate Indian citizen. And most of these people, Mathuas and Rajbansi, have been in India for a number of decades. They have, in the meantime, obtained all possible documents in order to establish themselves as citizens of India. And according to her, and which is true, if you apply, that means first thing you have to say that you are an immigrant. You are not a citizen, because if you are a citizen, why are you able to apply? Why do you need to apply? And this is probably going to this argument and counter argument is going to play a very, very big role as a vote bank politics of West Bengal and possibly also in Assam. The state of West Bengal, Kerala, Tamil Nadu, their leadership there, the parties in power, have announced that they will not allow this legislation, CAA, to be applied to the people of their state. Indian Constitution has 3 lists. One is the union list, which is a central list, and the other state list, and third is a concurrent list. The citizenship is on the central list, but application of procedures through which it has to be done, it will be done by the states. The mandate of the central government will have to be followed in a prescribed manner by the states. States can delay, but in my opinion, they cannot refuse the application of a law which has been passed by the parliament. So therefore, this declaration or announcement of these 3 states is not really meaningful. It's not a rewarding reply to the opposition of this legislation. The earlier people applying for Indian citizenship had to prove many things, including the fact that they speak one of the Indian languages as prescribed in the Constitution, recognized languages. But now that has been done away with. The self-declaratory affidavit saying that I can speak and read and write, and maybe another person can also endorse it, will be enough. There's no need. This is also discriminatory because others applying in a normal course after having stayed in this country for 11 years will have to have all those qualifications to be established. So discrimination galore in this legislation is bound to affect the decision, whatever is made by the Supreme Court, which is considering the petitions, 237 petitions in the opposition of this legislation. Now, have the impact of this legislation is not going to be all over the country, but statements made by the people close to a seat of authority at the NRC, that is the national exercise for establishing nationality of all Indian citizens through the national registration of citizenship, will be conducted all over the country. This has become an instrument of fear, politics of fear. There are many people in rural areas, even in semi-urban areas, who may not have enough documents to establish that they are citizens of India. So what will happen to them? Therefore, this exercise has generated fear in the minds of minorities within the country. And mainly the Muslims. That means there will be through this exercise, arbitrarily, you will be able to determine so and so is a citizen and so is not a citizen of this country. That is dividing the country based upon religion, based upon discrimination, based upon the principles which clearly violate the philosophy and the ethos of the Constitution of India. I don't think this is going to stand the test. But one doesn't know. It still depends upon the articulation or presentation of arguments before the Supreme Court. Supreme Court presently is seized of very highly sensitive and qualified judges who are extremely concerned about the preservation of the dignity and human rights and the fundamental rights guaranteed by the Constitution. For example, recently, last month, the High Court of Uttar Pradesh in the Lucknow bench had abrogated a law passed in 2004 about the management of madrasas. It was a Madrasa Act of 2004. And they abrogated it on the ground that no special arrangements can be made for the madrasas. It violates the principles of secularism. Whereas the other similar kind of schools are working, called gurukuls are working, and many other Christian schools are working. And there was no there was no similar impact on their functioning. The matter went to Supreme Court 2 days ago only. The Supreme Court passed a stay order against the operation of the High Court judgment, and they said prima facie it looks like that the interpretation of the Supreme Court understanding of the High Court of Allahabad, High Court of Allahabad Lucknow bench seems to be erroneous and faulty. Now, if that was not to be so, what would have happened? 1,700,000 students studying in these madrasas would have no place to go, though the direction of the High Court was to be adjusted in the regular schools, because what they thought was that these madrasas are not giving quality education. As under Article 21A, the state is obliged to make sure that the children from the age of up to the age of 14, the definition of a child up to the age of 14, should get quality education. And the madrasas are only teaching Quranic and Sharia related education, and they are not given the education in other subjects like science, English, computer science, biology, geography. So their education as a result is not complete, and there's no point having education system in an institution which doesn't prepare children for any future possible skills and employment. But Supreme Court realized that this is the High Court could have given guidance, could have said that no, we find that the education is not as quality of education is not as required by the normal standards prevailing under the Right of Education Act. Please improvise, change, do something in order to prepare these children like any other mainstream schools. Instead of that, abrogating that act was not a solution. So therefore, I have great faith in the wisdom of our judges, our judiciary, and I feel that all that seems to be wrong at the moment with this legislation will be corrected. The legislation has value. It's laudable that we are concerned about the atrocities being committed on our some people of our in the neighborhood. But what could stop the government, including some few more from these countries only, those who are persecuted, instead of identifying them by religion, that they should be Hindu, Sikh, Christian, Parsi, Baudd, and Jain, instead of identifying them, they could have possibly said all minorities from who are persecuted or are in the fear of being persecuted would be welcomed. If this could have been the language of this legislation, probably there would be less impact and less criticism. But no, the purpose of the legislation was to somehow show favor, privilege to only a certain section of society, and also thereby generating a fear in the minds of Indian citizens who are minority here in India. Now, this complete lack of consideration and in the air of arrogance of being arbitrary is not going to work with the people. People are quite concerned about it. Though those who are not Muslims, even they are concerned about it. Why? Because of the healthy climate and the political stability of the country, which is very conducive for the progress and development and growth. However, this legislation at the moment is there to stay till set aside. No stay has been granted by the Supreme Court. And as a result, we all have to wait and see what happens and how this is going to really benefit the majority party in the coming elections. I think I will stop here. I will be very happy to answer the questions, if any, or elaborate on any point which has been made. Thank you. And thank you for your
Thank you, Dr.
patience.
Sona Khan. Let us hear the concluding remarks by Ambassador Fabian, and after that, we will enter into question and answer session.
Thank you so much, Dr. Rasi Yusuyuddin, Dr. Sona Khan, Dr. Bhanumati Sharma, dear diaspora in Washington and elsewhere in North America, and fellow citizens in India. I suppose I can almost say good afternoon and also good evening. Now, Dr. Rasiuddin, it's a beautifully small world. Were you in Aligarh Muslim University? Because I had gone there and spoken, well, sometime in the last millennium. Now, dear diaspora, before that, let me thank Dr. Bhanumati Sharma for that very cordial introduction. I have been around for so long, so sometimes, the introduction takes such a long time, but it was cordially brief. Thank you for that. Now, dear diaspora, I have had the privilege of dealing with the diaspora for almost 60 years. I started in Madagascar in 1965. Most of them were Gujaratis, and some of them were, in French, we used to call them apatride, that is, stateless. And I remember that a couple of thousands of them were granted Indian citizenship when they applied to the embassy. Of course, we made references to MEA, and which would have passed it on to MHA, which would have checked with the district magistrate. And, at that time, I want to emphasize, I never got any instruction saying that, look at the religion first. No, there was no such instruction. So, my only objection is linking religion to citizenship, as very brilliantly explained by Dr. Sona Khan. Now, she also mentioned about, among other things, ignoring Sri Lanka. Well, let me put it this way, at times, central government in Delhi may not be conversant with what is happening in the far south. Now, question, why CAA? Well, as we know, legislation is often, not always, a political act. And Dr. Sona Khan has mentioned the electoral politics involved, or, Now, one thing about the implementation of this act is that, India has 806 districts, and these district magistrates are the backbone of the administration. So my understanding is that earlier, the application had to be made to the district magistrate. He or she sort of processed it. Of course, decision was left basically with the Home Ministry. But now the district magistrates are no longer involved. In fact, they are constituting some empowered committee which includes tahsildars, that is, below the district magistrate, and then postmaster, generals, and this and that. So that is an important thing, the change in the implementation. Now, I want to ask the question, electoral politics is the only motivation? Well, to answer that, I think we need, a brief historical regression. 1947, the partition of India. There is a common impression that India was divided on the basis of religion. Well, to be logical about it, if Jinnah maintained that Muslims and Hindus cannot live in the same nation state, then all the Muslims in the subcontinent should have gone to Pakistan, and all the Hindus and non-Muslims rather, in not necessarily all the non-Muslims, but at least the Hindus should have come to India. Now, that didn't happen, and as we all know, at present there are and India is privileged to have 204 million, I repeat, 204 million Muslims, accounting for 14.2%. And India is home to 10.9% of Muslims globally. And India, sometime back, even wanted to be associated with OIC. So, to go back in history a little more, who first publicly called for the partition of India? Well, it was Lala Lajpat Roy. Way back in 1925, Lajpat Rai wrote in a letter to C.R. Das and said, I had devoted most of my time during the last 6 months to the study of Muslim history and Muslim law, and I am inclined to think Hindu-Muslim unity may be neither possible nor practicable. I do honestly and sincerely believe in the necessity and desirability of Hindu-Muslim unity. I am also fully prepared to trust the Muslim leaders. But what about the injections of Quran and Hadith? And what is more interesting is that he uncannily foretold the actual partition. He said Punjab should be partitioned into two provinces, the Western Punjab with a larger Muslim majority to be a Muslim governed province and all that. Now let me quote from Tarachand, famous historian. The partition of India was not the product of the fertile imagination of the Muslim undergraduates of the Cambridge University, nor even poetic Baal's fancy, but the brainchild of a hypersensitive Hindu stalwart. So, now, let me put it this way. There is a determined effort to turn into a Hindu Rashtra. That is mirror image of Pakistan as conceived by Jinnah, or at least as stated by Jinnah. Well, Jinnah might have had other reasons for having Pakistan. Very briefly, at some point in time, he realized that he will not be the Prime Minister of undivided India because Mahatma Gandhi had declared that Jawaharlal Nehru will be his political heir. So Jinnah went to, he left politics, he went to England. Then later, the Muslim League sort of persuaded him to come. But one more point I want to make, and that is that months before the Second World War started in September 1939, a lieutenant of Jinnah met the Secretary of State for India in London. The meeting was supposed to last only 10 minutes, but it lasted much longer. And the gist of it was that Jinnah's lieutenant told the Secretary of State, listen, you are going to leave the subcontinent tomorrow, day after. If you want a foothold there, you can count on us. And the Secretary of State gave the green signal that the British government would support the partition. And later, the Secretary of State made a statement in the House of Commons. But that was after the famous Lahore Resolution of March 1940. But the point is, before presenting the resolution, Jinnah had every reason to believe that the British government was with him. Now it's like this. In a Euclidean triangle, two sides together are always longer than the third side. And the three sides were the British imperialist power, the Indian National Congress, and the Muslim League. And the British imperialist power and the Muslim League wanted partition, and Congress could not have done anything about it. Now the last point. Since the Hindu Rashtra will be a mirror image of what Jinnah preached, well, I'm reminded of the saying, imitation is the sincerest compliment. So the BJP is complimenting Jinnah even after realizing that Jinnah's formula of a religion-based state was disproved by world history in 1971. As the saying goes, world history is a world court of justice. Thank you so much, dear friends, for lending me your ears so graciously.
Thank you, Ambassador Fabian, and thank you all the other two speakers, especially Dr. Sona Khan and Dr. Bhanumati. And now we will enter into the question and answer session. But before that, just an announcement for the coming Saturday, and then we will hand over to Dr. Rafat Hussain. Faisal? It will be a very interesting another session. The main speaker is a very young fellow, a research fellow at the Center for Modern Indian Studies in Germany. But he has worked very well, and his articles have become very famous actually in a very short time. And so he will be joined by two very tall figures as a historians, Professor David Leliver. He will be introducing him, and Professor Barbara Metcalf will be giving the concluding remarks. You can imagine the importance of this young guy, Dr. Raza Khan from Germany. He will be speaking on minority past, locality, emotions, and belongings in the princely Rampur. And he has this book with the same name, as you can see on the left side on the poster. So now, thank you all, and over to Dr. Rafat Hussain for moderating this part of this session. Rafat?
Thank you, Dr. Raziuddin, and thank you to all speakers, Dr. Sona Khan, Dr. Bhanumati Sharma, and Ambassador Fabian. Thank you very much for participating in this session. It was a great talk. And let's begin the question and answer session. You can please raise your digital hand or show your interest in the chat box. And let's begin. If there is any raised hand, I don't see yet. And chat box. So there are few comments in chat box, and you see for Dr. Sona Khan, please, the Mool Nivasi movement argues that only the Dalits and the tribals are the original inhabitants of the Indian subcontinent, and the rest came here in time during past 2,000 to 3,000 years. What if they come to power in future, amend the Indian Citizenship Act, and ask all others to freshly apply for citizenship? That falls in a different category from that of the so-called original inhabitants. And this is from Himalaya. So this question is for Dr. Sona Khan. And if you want me, I can continue. There is one more question for you, but please go ahead and address this one first.
Thank you. I think as far as the people from Himalaya, original people of India are concerned, or Indus Valley civilization are concerned, that glorious past did not make any distinction between visitors, illegal or non-illegal. For example, the Siddhis of Zanjira were people who came from Addis Ababa now, and Ethiopia now. And at the time, the country had a different name. They came with the ships and settled down in Kerala and on the east coast of India. And they continue to be there. In Gujarat is Siddhi villages, and they still speak the African language. They still have their own culture. They still have the kinky hair, and they still have the same complexion. And they have assimilated, yet maintaining their own individual identity as Siddhis. And they were considered to be of great value to the coastal regimes, because when the Portuguese and others invaded our regime and did not allow the Indian administration at that time to collect revenue, which every ship is supposed to pay, these were the ones who really protected the cause of the coastal area for India, and they are respected. There are many other tribes who came from outside, and they were given tremendous amount of dignity and honor in order to rehabilitate themselves. And like Chakmas, they live in northeast Meghalaya, the Jeongs tribe, the tribes which during the British India time, migrated from Burma. They all settled in Mizoram and Tripura. They are part of Indian system, And there is no question about dislodging them in any possible way. Similarly, I believe and I feel, I very strongly, that our ancient past is far more glorious than it happens to be now under the pressure of political requirements and needs. Thank you.
Thank you so much. And let's begin with her second part. Dainik Bhaskar responded on 29th March that a local priest can provide the eligibility certificate to the applicants who apply after the CA. First, this will put people unnecessarily under the influence of the priest in their vicinity, even in the 3 neighboring countries. Part 2, if after the NRC people could not submit documents that prove their citizenship, they will have to heavily rely on the local priest even in India, because the government may apply the same standard here, and Muslim would not be able to do that either. Your thoughts, please, ma'am.
Well, this is true. 5 days ago, in Rajasthan, the certain Hindu organizations organized a ceremony to facilitate the application of 300 families, Hindu families, migrated from Pakistan, bordering Rajasthan and Gujarat. There, the priest had given the certificate that they are Hindus and they have been persecuted. Now, this seems a bit out of the line as far as the Indian Evidence Act is concerned. But however, the new rules which were pronounced on the 11th of March 2024, they do prescribe that a certificate from a priest. It's true that those even who are not Hindus, let's presume, for the sake of argument, they will be able to get the facility going to a priest saying that I am a Hindu, and the priest will certify, and accordingly they can be exploited. There is an element, possibility of the scope of the element of exploitation in this. It's true, but I think with the time and with the wear and tear, we would know more how this kind of a facility granted to the illegal immigrants to apply for a citizenship earlier than 11 years, within 5 years of their stay, will turn out to be, and the priests would be in great demand. In fact, this is going to provide a professional opportunities for people to become priests and Hindu priests, and do a very lucrative business. In any case, with the coming of the BJP, the religious traditions are being revived in a very big way, which many people had not even heard of. So the priests are always welcome.
Thank you, Dr. Khan. Another question from Alpana, and after that, Dr. Saizadi. Alpana Sharma says, I'm wondering why you didn't speak about political fatwa. And it was occurring, Dr. Khan. If Muslims can do wrong like this, it is a concern. Your thoughts?
Indeed, I agree. You see, unfortunately, with the assurance of the guarantees given in the Indian Constitution and by the political leadership at the time of partition of India to the Muslims, and that is why they chose to stay behind. All of them did not go. Most, as Ambassador Fabian pointed out, we are more than 14% of the Indian population, which is huge, second largest in the world, possibly. And after Indonesia, the error in whatever the plight Muslims are in India, to a large extent, that its leadership is responsible. In fact, according to Islamic law and jurisprudence, fatwa cannot be used for such purposes. This is wrong. Fatwas have a very limited purpose to serve, and all has to be done which is in accordance with the principles which are mandated by Quran and also by God. By God, we all believe as Muslims that the Quran is the word of God. So therefore, this has the Muslims themselves have used their instruments of great value to their own disadvantage. They thought by becoming a vote bank, they will be able to get some kind of a very special treatment from political leadership. Unfortunately, that has not happened. Political leadership only used them as a vote bank and abandoned them. They did not make any investment in them, in the value of that quality of their lives. And that is something worrisome. And it continues to be so. Now, most of them have realized that Muslim children are now studying. Earlier, they were not studying. I am very ashamed to say, but that's a fact, that our mosques and madrasas at some stage were, not now, but at some stage, were only preparing people to be less aware and less confident as citizens of the country. They, in order to supply unskilled labor to Muslim countries, which needed them most at very cheap wages. And this is how the economies of some of the Muslim countries in the Middle East have really come up because of the services provided by poor people from Afghanistan, from Pakistan, Bangladesh, and India, and also Philippines. I remember the first case that I dealt with was that of a Filipino woman who was accused of killing her employer because she was in the danger of losing her modesty and her honor. And I don't want to take the time in order to discuss the case, but ultimately she was freed on grounds that Islam does oblige a woman or any person to protect his or her honor, which is a primary duty, and therefore it was not a crime if it was in self-defense. So the point I'm trying to make is this, that the use of poor Muslims, those who are non-ashrafs, by ashrafs, has been very abusively used in India, and which is a matter of great shame.
Thank you so much, Dr. Khan. Dr. Saeedzadi, please.
So it's a quick question. In the history of like last 100 or 200 years, do we see any scenario, similar situation in any other country in the world?
I'm sorry,
You mean similar situation as the CA?
As the CA on the base of religion or caste or color, on immigration or?
Yes, there is an example. Lautenberg Amendment of the United States, when in 1990, Jews primarily were allowed to migrate only Jews were allowed to migrate. Later on, of course, Christians also, when the Soviet Union fell down and the countries which built the Soviet Union had seen a certain amount of persecution in those countries against the Jews and the Christians. So the American government at that time, maybe there were different considerations other than that faith, which probably we don't have the time to discuss. But this Lautenberg Amendment is one of those kinds.
सोना खान साहब जरा सा पीछे हो जाइए, थोड़ा सा आपका फेस ऐसे में ठीक है, आधा फेस रह रहा है आपका. Now, thank you. Maybe you can talk like whatever.
Sorry.
Sorry.
Okay. No problem. Thank you for your suggestion. And next question is for Ambassador Fabian. He must have read it, but I am going to read. Sir, you quoted Dr. Tarachand. Can you please provide the reference? Thank you for the deeply researched concluding remarks.
Thank you. Now, before giving that, I just want to go back to the previous question. If you want a state where religion and exercise of political rights is linked in an absolute way, look at Israel. Isn't it very clear? So that is that part of it. Now coming to the reference which you wanted, Tarachand, History of the Freedom Movement in India, Volume 4, Publications Division, Ministry of Information and Broadcasting, Government of India, New Delhi, 1972. Actually, it is all in my book, India in the 21st Century, where I have dealt with what happened, the partition and also the founding of the Muslim League and all that.
May I add? May I add to this?
Yeah, please go ahead.
There is a book called Partition of India by Mr. Sirvai that that includes, it is out of publication at the moment, but anybody who or the libraries may have the old copy. This letter, which was alluded to, includes that is included in that book also.
Okay. So I don't see any more questions or raised hand. And I'll one this. Okay. And there are more comments, but no questions. And let me put a few people on the spot now. Razi Bhai, do you want to invite someone?
Well, some of them left.
Yeah, I was looking for Fazal Bhai, our political expert. And
may I ask myself?
yeah, you will get an opportunity. Don't worry. But go ahead. Go ahead.
I'm curious for what Ambassador Fabian mentioned, that Jinnah Sahab, before moving to the two-nation concept, before that also, when living in Bombay, he was known as ambassador of Hindu-Muslim unity. He knew that it's the same Hindus, same Muslims. Then what really transformed him, if that is the politics in Indian subcontinent, that only targeting him was the reason really, or he became from a staunch secularist to a real communalist, like suddenly the same Hindus and Muslim are not to live together. I mean, for a long time, he didn't have the same, and he was of mature age, very smart fellow. So what changed? Did something change in India during this 1925 to 35? Did Hindus change? Did Muslims change? I mean, something must have changed to make Jinnah Sahib a little different than what he was. And he was known for a long time as really nothing to do with any kind of enmity or any kind of what you call any kind of uncomfortable feeling between the two communities. He was not known, but then he became this symbol. So what is this? What is all this? I mean, this has to be understood. May I get your some impressions, brief impression, or even in detail impression? We don't have many questions actually.
Thank you. It's a very important question. And what we have to understand is that, as I mentioned earlier, Jinnah was called the ambassador of Hindu-Muslim unity by none other than Sarojini Naidu, you know. So he was, but then you see he was a little alienated by Mahatma Gandhi's public agitation, you know, non-cooperation and all that. That alienated Jinnah, who believed that the best thing is to, you know, write memoranda and petitions to the imperial authorities, and they can be convinced by good arguments, you know, to get India independence. He didn't believe that Gandhian methods were the right one. How can you break the law? Things like that. That apart, Jinnah was held in high esteem when Gandhi came from South Africa, and everyone was looking up to him. But then Gandhi's star rose pretty fast, you know, and by late 1920s or even before that, you know, there was a time in India when people used to say Mahatma Gandhi ki jai before they used to say Bharat Mata ki jai. So then Gandhiji, I don't have the date now, but sometime in the late 20s said, Jawaharlal Nehru will be my political heir. Well, that was an indication that Jinnah stood no chance of being the prime minister of an undivided India. So he migrated to England. He practiced there very well. But then the Muslim League leaders in India, they went and persuaded him, and he agreed to come back. And as, what shall I say, as a strategist, well, Jinnah was slightly superior to his Congress adversaries. You know,
but something he didn't believe in, how could he use it? That's the question.
Well,
if he didn't believe in.
No, that is where political ambition comes. And this has been discussed at length, and the conclusion which I mentioned is corroborated by a professor of in Lahore. I'm sorry, I can't get his name immediately. I had moderated a discussion of his book at the IIC, and it is on our website.
May I add to it?
Sure.
The Khilafat movement was very well supported by India at that time, all the freedom fighters. And when Congress Party decided to send 2 people from the Congress Party, that upset Mr. Jinnah and the Muslim League, because they were not consulted, they were not included, and they thought that Khilafat movement in Turkey should have a representation of Muslims from the other parties too. This upset him very much. It's all recorded in Mr. Sipai's book.
Well, thank you very much. So since others are not asking, let me ask. I got a good chance now. I expected a little more in your talk, Dr. Sona Khan, on the real concern of Muslims, why they, in the first time in the Indian post-independence history, Muslims came out overwhelming number on these streets. So what was that? I mean, what was that danger felt, or whatever was it is, that they really so courageously they took up the constitutional, stuff in their hand and said that do or die kind of thing?
Well, it is very interesting question that you asked. In fact, I did not want to make it very dramatic in my presentation earlier, and that is why I left it out. The Shaheen Bagh protests, which were held in spite of a very bitter, cold and bitter winter, the people, mainly women, kept sitting there from morning till evening and going home only to get their children just for a while. It was a very consistent protest, very, very consistent. And also in Kanpur, other education institutions, IITs. And this was a kind of a desperation to protest. Why? Because what had happened in Assam, that so many people who were genuinely Indian citizens were left out and they were not included in the National Register for Citizenship. And they thought that by using the same exercise all over India, which was announced by the Home Minister in the Parliament, that they will have an NRC for the entire country. The Muslims thought that this is how they will lose. They are likely to lose, or they may lose, the Indian citizenship, and therefore they were very concerned. I wonder if any one of you remembers that there was a huge cry in the newspapers and on TV channels when Faiz Ahmad Faiz's poem "देखेंगे हम भी देखें लाजिम है कि हम भी देखेंगे" was considered to be a kind of an anti-Hindu poem because the wordings of the Urdu wordings of that poem were not really understood in the context that they were written by the poet, which was primarily to oppose the hard and strict regime, dictatorial regime of Ziaul Haq in Pakistan. It was written for that purpose, and it was perfectly it was fitting in perfectly and validly fitting into Indian conditions when this legislation in 2019 was passed. And it is a fear by making statements in the parliament that they will have an NRC like they had in Assam for the entire country was an instrument of fear politics, which is somehow was taken very seriously. And I don't think it can ever happen. The NRC will happen, population register will happen, population register will find out what is the population of India, which will include immigrants, illegal or legal, both, and foreigners. But then with the same, at the same time, the exercise would also demand documents from people to show and indicate their right of their citizenship. And this is what people thought probably their documents will not be believed. Because there are many cases in Assam where people have been living for 3 generations, 4 generations, and there are cases pending in the Supreme Court. 96, more than 9,600,000 people have filed applications and appeals against their the fact that they have been left out of the citizenship register. So they Muslims thought this is going to happen to them also, and they're even now they are very concerned because whenever it is suitable, these politics of generating fear is let loose. Though recently our Prime Minister had to come out and make a statement against what the Home Minister had said, that no, there will be no NRC in India, in Germany. Well, these are kinds of sentences which are used to calm down the situation or to provoke the constitution as it is suitable to the political party in power. However, people have lost their faith in these kind of exercises. They think their system would be prejudiced and will take a heavy toll on them and their resources. And as a result, they will have to wait in line for a number of days in order to furnish their documents and verification of those documents.
All right. Rafat, there are a couple of people.
Yeah, I'm checking. Okay. Yeah, Nazir Saab. I invited him. Dr. Nazir Ahmad, please.
My question relates to the power of the state and the incredibly shrinking capability or the rights of the individual. All over India, there were determined protests against the CAA and the NRC. We here in the United States also protested against it. There were so many cities in the United States that passed resolutions opposing or expressing their concerns about the NRC. And it seems to be a global phenomena that these states arrogate themselves to the authority, and the individual cannot do much about it. What is your comment about it? What can the ordinary citizen do to influence these global events? We see this in the Gaza situation at the present time. Any comment, please?
Well, you are right. The fundamental rights given in the Constitution are shrinking, primarily with the idea or with the presentation of argument that for security reasons, people have to be screened. The right of privacy is eroded constantly. People are frisked, people are detained unnecessarily without any evidence because they have a certain name or they have a certain caste listed in their documents. This is a real problem, security. And in the case of CAA in India, our research analysis wing and the National Investigation Agency both have very heavily cited cases that people would sneak into India in the name of being Hindus from these countries, which they may not be. So even that doesn't seem to be a deterrent at the moment for the present political party. However, it is on the basis of that Rohingya refugees were deported and they were kept in detention camps in Assam because they were considered to be a security risk, and their association somehow was established with the aggressively Wahhabi organization based in Bangladesh and elsewhere, and which is very unfortunate, making such a sweeping statement because there are Rohingyas who are really very much in need of help, and they have nothing to do with the terrorism or alleged aggressive organization which may harm India in some possible way. Security reasons are one. Second is the lack of understanding of the rights of the people, the awareness. Somehow the present education system of law and otherwise, unless you go to the court and take the matter to the court, and depending upon the decision of the judges in a particular issue, the articulation somehow otherwise is not really well placed as it used to be earlier. The law is becoming very complicated as far as the preservation of fundamental rights and equality and lack of discrimination is concerned. And this is something really to worry about. It's a global phenomenon. It's happening. For example, when I was dealing with the constitution of Eritrea and Benin, in Africa, I found that the mandate from the governments was to shrink the fundamental rights part of it, so that they will have political stability by virtue of an effective administration. The African Union, well, I'm making a very sweeping statement. I have seen in other constitutions also with somehow gradually the space for fundamental rights is shrinking all over. Take the case of Afghanistan. The Taliban have been there for a long time, and with their very twisted, misplaced concept of Sharia, they do anything. There are no rights available. They are sending their women to jail at the moment because their honor and dignity cannot be preserved outside. So it's better to put them in jail. This is, and the educational institutions have been stopped. The right of education as if for girls is not available. Whereas the Prophet himself said that you should go to get education and knowledge, and go as far as China is concerned at that time. Of course.
So there are a few questions. One, Dr. Abdul Jabbar, he has raised his hand, and there is a discussion between two. One is Himalaya and another is Alpanaji, and that is very interesting discussion that Rafat should raise, and a brief response is needed. But first, Dr. Abdul Jabbar.
Yeah, I'm reading that.
Yeah,
Sorry. Yeah.
thank you. Fantastic, as usual. I think we are all learning, reading about CAA, NRC. I think it's revealing that the Supreme Court in front of it has 200 plus petitions. So in terms of coming out some sort of decision on the part of the Supreme Court, what is the timeline? What is that? Since you have been working with the Supreme Court discussions, so what do they want in terms of making decisions? They don't feel it's something pressing for them to make decisions at this stage, because Pratap Mehta I sent attached that article. He really makes comments about why Supreme Court has been very silent on this issue. Can you make some comments on that, given your insights on the Supreme Court functioning? Thank you. Great.
Well, I will not commit the offense of contempt of court by criticizing my own institution, to which I rely a great deal and have a great respect. However, you see, the Sabrimala temple issue has been pending for a very, very long time. Somebody filed a petition in the Supreme Court regarding some of the Islamic notions of Sharia, and they are anti-human rights. And that petition has been pending. And they said that they will take both of them together when we are dealing with Sabrimala. Sabrimala temple is a case where women from the age of 9 to 60 are not allowed to go inside the temple in order to worship, on account of their possibility of being impure at a certain time in a month. So now this is pending. Whereas the Kerala government, where the temple is situated, has made a categorical statement before the Supreme Court everywhere that they support the rights of the women to worship, and that cannot be stopped. Similarly, another temple in Madras, in Tamil Nadu, sorry, was where the priest died and his wife wanted to go and perform with her son certain rituals which are necessary after the death of the person inside the temple, because he was a priest of that temple. And it was objected to, but however, when she approached the court allowed her and permitted her. Now, this is the way the judiciary functions. And taking so much of time to consider, well, they have too many precious cases. And most of the time of the courts is being taken by political petitions. By the way, I must also clarify that petitions which go before the Supreme Court, either by way of appeal or otherwise by way of writ petitions under Article 32, are the ones which involve the point of law, not point of fact. Only if you have an element of point of law involved and you feel that this needs to be clarified, they will go to Supreme Court. The Supreme Court has tremendous pressure from all sides. The other thing is that though there is no adjournment, as it happens in High Court and the lower court judiciary, if the case is listed, well, it jolly well will be taken, and you better be prepared for it. You can't say that you're sick or something. You have to make an alternative arrangement in case you don't happen to be available on that day. However, the Supreme Court is not deliberately delaying it, because there are 237 petitions as far as CAA is concerned at the moment pending. Maybe when I last read the figures, the petitions may have been increased because people are now asking for stay in the operation of the CAA till the matter is decided. And Supreme Court has refused stay for the moment, but maybe they will change their mind in case there is a compelling argument. Now, what arguments are being presented by the main lawyers for the petitioner? One is IMLU, the Indian Muslim League, and the Assam Students Union, and the other organizations, is mainly on the fact that when illegal immigrants crossed over into India, there were two very historical events. One was 1971, when Bangladesh came into being after getting away from West Pakistan. And the second is thereafter, when Mujibur Rahman was not allowed to take oath. And later on, there was a pact between Mrs. Indira Gandhi and Mujibur Rahman, saying that the minorities in both the countries would be well taken care of and would be respected. India did its part, but somehow in Bangladesh it could not happen. Recently, in a case from UP, where a Gadi Nashin was visiting Dhaka, and Gadi Nashin of a Dargah was visiting Dhaka, and he died there. His mortal remains are buried there. And he had gone to Dhaka via Pakistan. Before that, he visited Pakistan, or he migrated, and I'm not very sure of the fact. But somehow he was in Pakistan before going to Dhaka. Now, the Prayagraj Mosque, the city mosque, the Grand Mosque, applied to the High Court that his mortal remains should be allowed to come to India, so that they could be buried at the same dargah of which he was a Gadi Nashin, the controller or administrator of that dargah, and that would be tended well and in accordance with the dignity that he deserves. Article 21 of the Constitution of India says that dignity in death is a part of right to life. Article 21 deals with right to life, and they said the dignity to be accorded to a person when dead is a part of the right to life. As a result, every person should have a dignified end. Now, this petition, according to me, I can be wrong, was not very properly argued, was not properly presented. All facts were very vague. As a result, it was dismissed. And the matter went before the Supreme Court also. And Supreme Court said, who will exhume the mortal remains? India cannot have jurisdiction in Bangladesh. Bangladesh government will have to be requested. And why should they do that? Because are we to believe that his mortal remains would not have a dignified existence? Now, he was a Sufi, the person. And the Sufism is not at the moment very popular in Bangladesh. And there are reasons to believe that his grave may not be properly looked after. However, the matter was again not properly presented, was not properly argued, and the courts go by the material available in front of them. And of course, the sumo also take note of their own knowledge and their own the availability of the evidence, otherwise outside the case. However, in this case, it was not available. Now, this is very interesting. Indian origin, Gadi Nashin in India, the administrator of a huge shrine in Allahabad, then dying in Dhaka. Now, I'm not so sure, Ambassador Fabian can tell us, whether there's a treaty of exporting mortal remains to another country or not. However, Air India was checked and Air India said that we have no problem, we can transport it. That certificate was also attached with it. But I feel that these touchy things, these are also a matter of faith. They need to be respected somehow, and they need to be looked after. The denial to such basic issues related with faith generate a tremendous amount of disinterest, and also kind of it hurts a certain section of society, certain section of people.
Let's stop that on here. So only few minutes are left now, and I'm gonna to compile for the sake of time couple of
I'm sorry, forgive me. I go when I will feel very passionate about this.
I see that.
I just insert, looks to me you have a great confidence in the institution of Supreme Court. That's,
I do.
Just be brief because of the time. Be brief.
okay, that's fine. I'm done. Thank you.
Only few minutes left, and I'm gonna to compile the discussion going on between Jabbar Saab and Alpana and Himalaya. So one of the concern or the what's his name? Himalaya said the Jinnah wanted to have a 10-year hiatus period to see if how does the Muslim do in the United India. And of course, Nehru and Patel did not agree with that. Another concern shown by Alpana is minorities in Pakistan are reduced to 3% from 30%. And if all Hindus were considered just Hindus, then they couldn't have been SC, ST, OBC, etc. And then the division on the basis of region. Even Brahmins of UP have Saryupari and Kanya Kubiji, etc. So the formation and development community. So this is a discussion going on. It does not need any input from you guys, but if you wanted to say a few words in 2-3 minutes, that would be fine. Or you can choose not to answer any of those questions, because these are not the questions, they are the comments. So back to you, both of you, Ambassador Fabian and Dr. Khan.
If I may,
Yeah, sure.
As brief as necessary. I had mentioned about a book on Jinnah, and that is Jinnah, His Successes, Failures and Role in History, Ishtiaq Ahmed. He is in Lahore. He was earlier in...
No, he is in Netherlands. He is
no. Well, he had come to Delhi the other day. He travels.
Presently, he will be. Yeah, presently.
Anyway, but I just want to make a point about another question, and that is, the state encroaching upon the liberties of the citizens. Now, this is a serious matter, not only in India. And what is happening is that the principle of Montesquieu, that, the executive, the legislature, and the judiciary should not encroach into each other's realm. That is being forgotten. And in India and elsewhere also, the executive is having, if I may say so, very big growth at the cost of the other two. Now that is a tendency which should be resisted. And second thing is a mindset. Many people believe that the state is something divine, state is something absolute, as Hegel said, and the state is above morality. I'm sorry, I do not agree, because state A is an instrument created by human beings for their own good. B, the state power is exercised by human beings, and no human being is above morality. You can be immoral. You may not be always moral, but you are never immoral. You are always, you come under ethics.
I just want to add that Article 13 of the Constitution of India gives power to the judiciary to evaluate and see each and every law or action of the executive is in conformity with the spirit and provisions of the Constitution. And if not, then it can be abrogated, it can be struck down. And that is a great power. India is a constitutional parliamentary democracy based upon English system. England doesn't have a written constitution. We have a written constitution, an excellent piece of work. And we don't have a king or queen, but we do have a president of India, which is elected body and not inherited. But though, however, India is in the process of discovering a king, executive king.
Thank you so much. And that concludes the question and answer and comment section. Thank you everyone for participating, and thanks again to all speakers, Dr. Khan, Dr. Sharma, and Ambassador Fabian. It was a wonderful session. And for the final remark or closing remark, you can say, I give it back to Dr. Razi Raziuddin. We are already over time, so please go ahead and conclude it.
Well, you already concluded. There is really nothing more to add. We are